Right off the bat, the facts of this case are pretty crazy. A member of the Mongol Motorcycle Club kidnaps a 68-year-old woman. He drugs her, drives around with her, threatens to kill her, and says that he doesn't leave any witnesses behind. Now, all of this because there's a dispute between this man and the woman's son over some stolen marijuana. Eventually, the two men get a hold of each other by cell phone. They resolve their issues. The man drives the 60-year-old woman back to her house, and you might think it all ends here. But of course it doesn't. The police get involved. In fact, the police officers issue be on the lookout, and they're trying to make an arrest. Now, how should the police proceed in this situation? Of course, they can try to get an arrest warrant, and surely they were able to do it. You would think. They have witnesses. You have the victim, the woman, who tells the officers what happened. But instead of getting a warrant, police officers simply show up to this man's house at 4 a.m. in the morning. They knock on the front door and try to get him out of the house. They eventually succeed. He jumps out of the back window into his backyard. They make an arrest. But think about it. The Fourth Amendment protects you against unreasonable searches and seizures. And it doesn't only protect you within your house, it also protects you in the area called curtilage, the area that surrounds your home. And here you have the officers who, without a warrant, approached on the curtilage to knock on the front door. Now they're trying to use an exception called knock and talk, which allows officers, just like anybody else in the general public, to knock on the front door. But the court here says, I don't think so. I don't think the knock and talk exception works in this situation where the officers are clearly trying to make an arrest. So let's take a look at this case and figure out whether this was a valid arrest and whether the search that proceeded was also legal. And by the way, I completely forgot to introduce myself. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. I handle cases throughout California and Nevada. So you have a case, give me a call and we'll discuss it. And in the meantime, hit that subscribe button, share my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, stickers, and other items. Thanks for watching.
Quick message from LawStache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LawStache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing United States versus Eric Lundin. Now, I gave you a pretty good introduction so you know some of the facts, but let's go ahead and fill in some of the blanks. We have officers who are being dispatched to a hospital where a 68-year-old woman is being treated, and she tells the officers this story. Mr. Eric Lundin showed up to her mobile home. He showed her 2 pistols. He took them out of his pockets. He then broke this woman's television and started to threaten her. Something about her son. He then forced this woman to take some prescription medication or some kind of pills. He kidnaps the woman, starts to drive with her in his pickup truck, threatens to kill her, says that he's a member of the Mongol Motorcycle Club, and he doesn't leave any witnesses behind. As they drive around, he also points out places where he would bury the body, meaning if he kills her. Now, at some point, Lundin calls this woman's son. They start talking on the phone, and even though there's a dispute over stolen marijuana, they eventually come to a resolution. I think Lundin recognized that this man actually did not steal the marijuana. So at this point, Mr. Lundin drives the woman back to her house. He, of course, threatens her, says not to call the police. But of course, here we are. When the police interviews this woman, the son also comes to the hospital. He tells the officers that when he got back to the house, he saw the whole place in disarray, the television was broken. So at this point, the officers issued be on the lookout. Deputy Aponte asked dispatch to issue a be on the lookout, BOLO, for Lundin and a request for Lundin's arrest under California Penal Code Section 836. Now, Section 836 authorizes a warrantless arrest when there is probable cause to believe a suspect has committed a felony. However, Section 836 does not, because it may not, authorize a warrantless arrest of a suspect in his home. Aponte believed that there was probable cause to arrest Lundin for burglary, false imprisonment, kidnapping, vandalism, brandishing a firearm, administering a drug to commit a felony, administering a controlled substance, and battery. HCSO dispatch issued BOLO an arrest request just before 2 a.m. Now, you just heard that the officers believed that they had probable cause to arrest Lundin pursuant to Section 836. Now, remember, they can't use this section to make an arrest within Lundin's home. So what should they do? Well, one thing they could do is, using the probable cause, write an affidavit and get a magistrate to issue a warrant for Lundin's arrest. Do they do that here? No, they don't. Instead, they simply show up to Lundin's home at 4 a.m. in the morning. They approach the front door, they knock on it, they don't even announce themselves as the police. They wait a few seconds. When there's no answer, they knock on the door again. A few seconds later, they hear some crashing sounds coming from the back. The officers run around the house. They see Lundin within the enclosed patio. It is fenced. They instruct Lundin to put his hands up. They go into the patio, make an arrest, handcuff him, and then they search the home. Within the house, in plain view, they find 2 firearms that were earlier described by the woman. It is the same 2 firearms in a Ziploc bag. They then, of course, take Mr. Lundin to the police station. Using the information they had, plus the fact that they just found 2 firearms inside the house, they ask a magistrate to issue a warrant to search the home. Now, of course, this would be the second search of the house. Now, later, Mr. Lundin argues for the suppression of the evidence based on violation of his Fourth Amendment rights for pretty simple reasons. He says that the officers were never permitted to go into the house without a warrant after they made the arrest. And in fact, he says they should have never been able to come to his front door and try to make an arrest without a warrant by trying to knock on the door. He also says that the second search that yielded any of the evidence should also be suppressed because that warrant was issued based on the facts that should have never been included, the 2 firearms that were found illegally. Of course, in order to figure out whether any exceptions apply here, or whether the officers violated Lundin's Fourth Amendment rights, let's take a look at the Fourth Amendment and see what it says. Let's start by reading the text of the Fourth Amendment. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. At its very core stands the right of a person to retreat into his own home and there be free from unreasonable governmental intrusions. Searches and seizures inside a home without a warrant are therefore presumptively unreasonable. Evidence derived from an illegal search cannot constitute proof against the victim of the search. It is undisputed that the officers seized the 2 firearms after a warrantless search of Lundin's home. So we can presume that this was unreasonable under the Fourth Amendment. But of course, the government can try to rely on some exception to the warrant requirement under the Fourth Amendment that has previously been enumerated by the Supreme Court. They first start with an exception called exigent circumstances. Law enforcement officers may conduct a warrantless search of a home when the exigencies of the situation make the needs of law enforcement so compelling that a warrantless search is objectively reasonable under the Fourth Amendment. However, exigent circumstances cannot justify a warrantless search when the police create the exigency by engaging in a conduct that violates the Fourth Amendment. Now here you might ask yourself, what was the exigency? They had the information, they issued be on the lookout. They could have went and got the warrant, but they didn't here. Well, the government claims that the exigency was when they got to the house, they heard crashing noises coming from the back, and so they had to act and get in the back of the house and make the arrest. But of course, that presumes that the officers were lawfully standing on Lundin's front porch and knocked on the door. But that's the very question. Was that permitted for them to be in that location? Was that a lawful area for them to be at? The area immediately surrounding and associated with the home, called the curtilage, is treated as part of the home itself for the Fourth Amendment purposes. Like searches and seizures inside the home itself, searches and seizures in the curtilage without a warrant are also presumptively unreasonable. The presumption against warrantless searches and seizures would be of little practical value if the state's agents could stand in the home's porch or side garden and toll for evidence with impunity. The government agent conducts a search within the meaning of the Fourth Amendment when the agent infringes an expectation of privacy that society is prepared to consider reasonable, or physically occupies private property for the purpose of obtaining information. We know that the officers physically occupied the area of Mr. Lundin's curtilage when they approached and knocked on the door. So you might think it should really end here. But instead, the government tries to rely on the knock and talk exception. Now, under this exception, officers are permitted to encroach on the curtilage, to knock on the front door, and try to engage in a good faith conversation with the occupants, usually to ask questions. Now, this exception stems from the customs of the country. If the officers are permitted to knock on the front door, that is because we let any persons of general public to come up to the front door and also knock on it to try to engage with the occupants. Now, whenever I post about this exception, I always get in the comments about having fences or cameras or signs do not trespass. Of course, if you have any of that, that might stop a regular citizen and should also stop the officers from approaching the front door and trying to use the knock and talk exception. But here, the court actually gives a couple more reasons why the knock and talk cannot apply in this case. First one is the reasonable hour. People are expecting visitors to knock on their door during normal business hours. And here the officers approach Lundin's home at 4 a.m. in the morning. Nobody in their right mind expects people to knock on their front door at 4 a.m. in the morning to try to engage with them in a conversation. The court says, of course, there are exceptions to exceptions. Sometimes individuals sell morning breakfast croissants to their neighbors, and so they expect people to knock on their door early in the morning. I know this is a ridiculous example, but it is one that the court gives us. And the other one, they tell that sometimes neighbors might knock on your front door at early hours to tell you that there's a fox next to your hens. Now, again, a strange examples, but that's what the court gives us. Here, of course, there is no excuse why the officers needed to knock on the front door at 4 a.m. in the morning. And the second thing about customs is the fact that we can look at the intent of the visitor. Here the officers were not trying to simply knock on the door and engage with the defendant here, Mr. Lundin. Instead, they came to the front door with a specific intent to arrest him. They knocked on the door, they didn't identify themselves as the police. And the whole time, the whole idea was to arrest Lundin. And because of these two reasons, the court says that knock and talk exception doesn't apply. And that means they were not there lawfully in the first place. The fact that they heard the noises, that noise did not create exigent circumstances because the officers themselves created this exigency by being there illegally in the first place. The government then tries to justify the search of the home under the protective sweep theory. The protective sweep doctrine authorizes quick and limited warrantless inspections of those spaces where a person may be found when there are articulable facts which, taken together with the rational inference from those facts, would warrant a reasonably prudent officer in believing that the area to be swept harbored an individual posing a danger to those on the arrest scene. By the time the officers conducted the search of the home, Mr. Lundin was already in handcuffs and placed in the back of a patrol cruiser. So at this point, there is no danger to the officers. There's no reason to believe that he was working with anybody else or that other people were inside the house that posed any danger to the officers. So really, the protective sweep does not work in this situation, says the court. There is no danger to the officers. And finally, the government tries to use inevitable discovery, meaning that the officers would have found this information anyway because they would have ended up getting a warrant for the house. They would have been able to find the firearms with that warrant because, after all, they had probable cause to search the home and arrest Mr. Lundin. They had the two witnesses, you have the victim, you have the son, you of course have some of the evidence in the house like the broken TV and so on to corroborate the information given to the officers. But here the court says inevitable discovery does not work because it will encourage officers who have probable cause to obtain a warrant and who fail to do so simply never get warrant in this situation because they will know that inevitable discovery would save them. Without a warrant, the information, all the evidence would still come in. So, under the inevitable discovery rule, if the officers have probable cause to get a warrant and they fail to do so, that evidence should still be suppressed. So at the end of the day, none of the exceptions, the exigent circumstances, inevitable discovery, and the protective sweep, none of these exceptions apply, and the evidence found in the home, the two firearms, should be suppressed and cannot be used against Mr. Lundin in court. If you learned something in this video about curtilage and how protective sweeps and of course arrests, knock and talk work, I hope you give this video a thumbs up. Please subscribe to my channel and share it with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, stickers, and other items. I have a couple new brand new stickers, which I will throw in with any of the t-shirt purchases. Thanks for watching.